So welcome everybody. My name is Jeff Gilmour from the Association of Residential Communities. Thanks for downloading this video. You're going to find it extremely interesting because it's about POPIA, the Protection of Personal Information Act. We know that it has now been promulgated and signed. In fact, it's already in effect. We'll find out just now how long we've got to take to make sure that we are completely compliant. And to help us do that, we've got our business partners from Cox Yeats, and we're joined by two ladies, Lazelle Paola and Jenna Padoa. They are two partners inside the legal firm. And obviously, when POPIA became a reality, well, we've known that it's been a reality for a while, but now it's been promulgated. And of course, the first things that we did, and the first thing that we want to bring to you as ARC members, is to try and get a grip on some of the issues around POPIA. So welcome, Lazelle, welcome, Jenna. It's so wonderful to have you. Obviously, at the end of this video will be a slide with all of your contact details, and we'd encourage all of the members and business partners and others who download this video to contact Lazelle or Jenna, where they will be able to help you with a little bit more detail. Clearly, what Cox Yeats are doing through Lazelle and Jenna is they're going to be offering a service related to POPIA, which could involve a whole range of activities, specifically from a legal perspective and making sure that we remain completely compliant. Probably the most important piece of legislation that has entered our industry, well, entered the country, but most certainly our industry for a long time. So it's great to have you two ladies, and we're going to kick right off. Jenna, I'm going to start with you, if you don't mind, maybe with the most basic of questions. So what is POPIA? Help us with that.
Sure, Jeff. Well, thanks for having us. So POPIA, or POPIA, is the Protection of Personal Information Act. And it is the first piece of legislation in South Africa that specifically focuses on data protection. Now, POPIA seeks to give effect to the right to privacy, which is enshrined in our Constitution, and prescribes certain conditions for the lawful processing of personal information. Now, what is personal information? It's any information relating to an identifiable natural person, or, where applicable, a juristic person. And so what POPIA is really concerned with is the processing of that personal information. And by processing, what is meant is anything to do with personal information, including the collection, storage, use, or even dissemination of that information.
So, wow, that's amazing. So while you were dealing with that and answering that question, I was just trying to visualize one of our communities. And I just pictured our gate, I pictured the office, I pictured the clubhouse, I pictured owners, residents, tenants, members, service providers, visitors, guests, grannies, grandpas, all of these people entering our communities. Exactly. And I thought, wow, is this relevant to us? Well, of course it is. Lazelle, maybe you could answer that question. So is POPIA relevant to communities? Is it really relevant to residential estates in this country? And if so, why?
Jeff, private estates and gated residential communities are invariably in possession of collect, store, or use private information of their residents, of visitors, of service providers, of employees within the estates. And even though residential communities or estates are not in the business of personal information or data capturing, or even necessarily use such information on a daily basis, the mere fact that they do collect, store, or otherwise process personal information, be it of residents, employees that work within the estate, service providers, visitors to the estates, is sufficient to bring them within the ambit of POPIA and the need to obviously then comply. So for example, Jeff, just a practical one, by the time a person is permitted entry into an estate, they would have parted with a fairly substantial amount of personal information already. It would be their name, contact details, ID numbers, registration numbers of vehicles, perhaps driver's license information. Yeah. And all of that then needs to be safely and securely stored and protected.
Okay, that's unbelievable. So somebody arriving at the main gate, as is normally practiced, will give out to the security guard a certain amount of information, and that information is data, and by default they are capturing that data, and therefore that data that is captured needs to be protected. It needs to be protected, yes. It needs to be used properly, it needs to be stored properly. So it's very relevant. Is it not, Lazelle? It's very relevant to residential estate.
Yes, and I mean, think even in the sales process, when you're buying into an estate, the amount of information you need to part with in order to lawfully acquire a property within an estate. It would start right with the estate agents, with the developer collecting all of your information, with it then being processed for the transfer process. So everyone in that chain essentially also falls under the obligations that POPIA imposes.
Okay, so we've got communities. Thanks for that, Lazelle. We've got communities that are going to start to feel a little bit scared already. I can just see it. We're going to be others that will claim that they are already way down the road with POPIA, and we've been alerted to the fact that this isn't only about putting up a sign somewhere. It's not only about a little pop-up on our website which says we are POPIA compliant. There's a hell of a lot more to it. Name for us, Jenna, if you don't mind. I think let's ask for about 3 key features and requirements of POPIA that we need to consider.
Sure, Jeff. So firstly, I'd like to mention that POPIA is a principles-based piece of legislation, meaning that it does not prescribe a fixed set of rules, but rather principles that must be applied by organizations. Secondly, and very importantly, POPIA equips data subjects with a suite of rights. And these rights include the right to know when information about them is being collected, the right to know the purpose for that collection, and even the right to object to the processing of that information or the collection thereof. Thirdly, and very importantly for our residential communities, POPIA imposes a list of obligations on responsible parties when it comes to the processing of that personal information. One of the key requirements there is a pre-disclosure requirement where responsible parties are obliged to disclose to data subjects the reason for the processing or collection of their information.
So you are telling us that if you arrive at a gate of an estate, you're a data subject. If I am a tenant moving into one of the HOA members' homes and I've got to give certain information to be captured, I am a data subject. So that would be the definition of what a data subject is. Am I correct?
Absolutely. It's the person to whom that information relates.
Sure. So it's not only about...
So Jeff, just...
Yes, carry on.
Sorry, yeah, just going back to Lazelle's example, as that person pulls up to the gate at a residential community, they have the right to know what information of theirs is being collected, why it's being collected, and as I said, at the gate, then and there, they can object to the collection or processing of that information. Obviously, the responsible party, in this case the estate, will have certain rights themselves. For example, they could deny that person access perhaps, but all of those things would need to be considered by that estate.
So in here lies a strong need, because if you take me as a data subject arriving at a gate to go and visit my mom who lives on the estate, the first person I see is a security guard, and I have a right to know why my information is being given or what it's going to be used for. In there is going to lie a requirement for estates to think about training, to think about how they're going to make sure that our security guards are equipped to handle such things. So, you know, this is not a small task. This is a big task, and our members are going to need help with it. So, Lazelle, they're going to need help with it. What questions should communities be asking themselves now to prepare for POPIA?
Okay, Jeff, they can ask themselves such basic questions as, do they have a clear idea or picture of the personal information it is that they do collect and process throughout their organization? So what is it? They're going to be quite surprised when they start compiling that list. A lot of that might just seem, you know, like their run-of-the-mill day-to-day business of the association. But when they start unpacking it, they'll actually see how much of it actually is the personal information of a data subject. Okay. They also need to ask themselves whether they have a clear purpose for the collection and other processing of the personal information. They're not just collecting it for no reason. What is the purpose behind it? Clearly, they can't be taking that information and selling it to an organization to use for direct marketing purposes. Yeah. And that's generally not the reason why they're doing that. They're doing it so that they firstly have an idea of who's coming in and out, and all other purposes associated generally with the fulfillment of their MOI or constitution. One of the other questions critically is obviously whether data subjects have consented to the processing of their personal information. So once they've identified what information it is they collect and why they collect it, have they now got the consent? I know between Jenna and I, we've spent quite some time over the last few years when we've been revising the MOI and rules and other documents of our estates in providing POPIA consents. But as Jenna says, it doesn't end there. It doesn't end at just getting a blanket consent, because even that consent has to be carefully framed to identify what purposes the information is being sought, so that one can describe the ambit of the consent. So they're consenting to the association collecting it, and in my other example, they're not consenting to the association selling that information or providing it to a direct marketing company. It's for purposes associated with the fulfillment of the MOI and the management of the estates. Another question that they should be asking themselves is whether the data subjects are aware of the personal information that's being collected and the purpose for which they process it. People might be unaware of the fact that by letting in their guests at the gates, that information is being collected. And don't let for any second think that the example we're using is the only instance of collection of personal information. It's just your most obvious one in the context of an estate. It's not the only one. Sure. And you would think that people would be aware by producing their personal information in the transfer process that it's being used, but do they understand it may be going onto the HIA's database and being stored by them? It's them educating members, residents, and staff within the association as to the reasons why they collect and what they're collecting it for. The example that you used, Jeff, of the security guard doesn't just begin and end at the security guard. That would be the first face that a person sees collecting the information, but that information is going into a system that also needs to have integrity and be compliant along the way. And it's not necessarily just the security system of the estate. It may be the security database of the actual security provider. So that information is not just going to one repository necessarily. And then also the estate should be asking themselves whether they have an information officer critically, because that person is the one charged with the responsibility of actually implementing the requirements under the Act. Okay. To some extent, your associations may well have that information officer, as they were obliged to have an information officer in terms of the promotion of access to information. And I know we've previously spoken about POPIA. But in the context of POPIA, there's also a requirement for an information officer. And perhaps Jenna can just elaborate there for the benefit of the estates that are listening on the information officer requirements under POPIA.
Cool.
Sure. So, Lazelle, you've identified it correctly that the requirement to appoint an information officer actually stems from the Promotion of Access to Information Act. And what POPIA does is expands on the role of that information officer. It requires that that information officer conducts what it refers to as a personal information impact assessment. That information officer is responsible for conducting internal awareness sessions or ensuring that those sessions are conducted. And so, yeah, there's an entire host of responsibilities that are now being added onto that existing role of information officer.
Oh, that's so interesting. So, I was having a discussion the other day with one of our member estates, and their answer was, we've got a whole year. We've got a whole year to do this. The regulator must be a very, very nice lady, because she writes regulations and then she says, but you've got a year, so don't worry. That's not true. Am I right in saying that's not true? Let's say a community is thinking that, or their board is thinking that, and an estate hasn't started doing anything yet. They haven't started considering whether they're compliant, whether they can be compliant, what it's going to cost them to become compliant. Where do they start, Jenna? Where do they start?
Sure. Well, firstly, we'd like to encourage them not to panic, because as you've already identified, they do have some time, but it is important to get the wheels in motion now. And so where we'd recommend that they begin is with an information mapping sort of exercise, where, as Lazelle's mentioned, they get to grips with what information it is that they have on them already, what information they will be collecting in the future, and how they process that and who processes that.
Yes.
So yeah, that would be the first place to start. We'd then recommend a sort of gap analysis. And for this, the organizations would need some outside help, some expertise from IT specialists, as well as legal experts who are aware of the ins and outs of things. And that gap analysis would be to analyze where there are any gaps in terms of POPIA compliance, so where the organization may be falling short. Thereafter, it would be essential to have a look at their governance documents to make sure that those are aligned with the requirements of POPIA. And then lastly, you've already identified it, Jeff, and it is a responsibility on the information officer to ensure that this takes place, that being training. Training is absolutely essential, because you can have as many policies as you like, but if they're not implemented, you aren't actually getting implementation of the legislation. And so it really comes down to the key personnel who are going to be having access to this information or otherwise processing this information, that they are aware of their responsibilities and obligations.
So, Lazelle, would you recommend, or should estates be considering the appointment of an information officer sooner rather than later, so that that information officer can be part of the process in this whole analysis work and mapping work and gap analysis and training that Jenna was speaking about? Or is the appointment of an information officer the last thing that they do? Just a quick response to that, Lazelle.
No, I would say it should be one of the first steps they take, is identifying the appropriate person, because someone's got to be charged with responsibility of taking this project forward, because they're going to need to really identify it almost as a strategic project for the next year, is getting ready to make sure that come the 1st of July next year, they are ready to kick off and are compliant. As I say, Jeff, with our clients, we've been obviously alive to the fact that POPIA is going to be coming into effect. So we've been taking documentation to a certain point, but it's not far enough. And I've found that what we haven't had until now is a holistic approach. So states have maybe just been looking at it from a purely one-dimensional documentation perspective, have we built in POPI consents where we need to? Now they need to actually get to the nuts and bolts of it, and their actual day-to-day processing and understanding the bigger picture. So they all have that responsibility. I haven't yet come across a community there yet that I would say is good to go on POPI yet. And they need to, like Jenna says, conduct their risk assessments, conduct a full audit of the process, start preparing their maps. It's a lot of work that needs to be done, but it's not insurmountable, Jeff. It's just understanding it and getting that person in place who's going to run with the process and appoint the necessary professionals to guide them forward.
So, thank you for that, Lazelle. So with your experience and the work you do in the homeowners association environment, as well as a body corporate environment, let's call it a residential community environment, our members should then feel free to contact you should they want to hire you to assist them in firstly getting to grips with all of this at a deeper level maybe, and then to ensure that they are compliant along every step of the way in getting to be at a point where if a regulator or an official or an inspector knocks on the door and says, please can I see your information officer now as we've received a complaint, that they are happy to do that and are satisfied. Yes. that the board, who are volunteers and non-paid people, can at least sleep at night, because ultimately it's the board that's responsible for all of this. All right.
And they can kill two birds with one stone, Jeff, because there are a lot that also still need to get POPIA compliant as well. Obviously there weren't specific processes that they, as specific and detailed processes they needed to follow under POPI, but there were requirements for a POPIA manual. Many estates haven't had that. It hasn't been critical until now because the Act provides processes, but it's the appropriate time, since you're now tasked with getting POPI compliant, to just get the full suite of obligations under control, because that's also very useful for estates when presented with members wanting access to information. And this all dovetails very nicely. Anyone dealing with members or residents who wanting information, pressing for minutes of meetings, pressing for records, will understand that they've had to grapple with privacy issues, with whether the members or residents are actually entitled lawfully to access to the information. Yeah. So we can cover quite a in this kind of an exercise.
Fantastic. Jenna, any closing comments from you, or are we POPI'd out, as some people often say?
Never. No, we'd be happy to help.
Cool. Well, thank you, ladies. It was fantastic. What a great 20 or 30 minutes we've had. And you know, all I can say is I really encourage our members and non-members that download this video to seriously consider this piece of legislation. It is a critical piece of legislation, and we need to make sure that we meet the requirements, not necessarily just because it's a new law, because the rights of privacy is really important to all of us. So well done. Thank you for downloading the video. Please talk to Lazelle or Jenna if you need their details and you don't catch it on this video. Give me a ring or pop me a mail, Jeff@HOA Support, and I'll put you in touch directly with Lazelle and Jenna. So thank you, ladies, and we'll chat to you soon.